Okay, we qualify our rights. We all have rights. They go beyond actually those things listed in the Bill of Rights. The Bill of Rights was designed to be a for example. Read Alexander Hamilton's Federalist 84, in which he argues strongly against there being a Bill of Rights in the Constitution, because he says the Constitution itself is a Bill of Rights, and if we just identified just a few, future generations would think those were the only rights that we had. And in fact, we have all rights. What the Constitution does is it says these are the areas where we're going to carve out powers that we're going to give to the government that may in some ways infringe upon our rights. But even at that, we qualify our rights. You've got the right to free speech. But walk into Macy's with a bullhorn sometime. You'll discover you don't quite have the right of free speech that you thought. You have the right of privacy. But, there's any number of, send some letters suggesting that you're friends with Osama bin Laden and notice what happens. Or try to go through an airport screening and say, I just as soon not have my bag screened today. I have a Fourth Amendment right of privacy. You have the right not to testify against yourself, except in front of a grand jury, or if you've been given congressional immunity. So we qualify even the most sacred of our rights. We qualify. The Supreme Court has before it a case, the McDonald case, and they're hearing arguments, I believe, today on this case. And in this case, the city of Chicago has said that you may own a rifle to defend your home, but not a handgun. And Mr. McDonald is challenging that, saying, I want to have a handgun. My house has been broken into 3 times. Somebody breaks in next time, I want to shoot him. And I don't want to have to bother looking for a rifle to do it. Now, there is concern that the Supreme Court is going to go after this, particularly the 5 conservative justices, in the same way they went after the funding of campaign finance stuff with Citizens United case, with an absolute blunderbuss, and blow the whole thing out of the water. Thus, if they rule broadly enough, they may outlaw laws in various municipalities, counties, and states around the country that that require people to have gun locks, that require them to have their guns locked up, that say that in some places you can have a pistol, or a long gun, but not a pistol, et cetera, et cetera. You can't have, for example, in urban areas, New York City, you can't have a rifle with a scope on it, stuff like that. That all those laws may go out the window. Larry Pratt is back with us. He's been with us many times. He's the executive director of Gun Owners of America. He's been there for 26 years. Gunowners.org is the website. Larry, you think the Supreme Court's going to take us back to the old West, guns, poker, and whiskey in your local saloon?
Well, I'd like to think so, but actually I'm pretty sure they're going to keep it narrow the way they did in the Heller decision. The way the case has been brought to them, it pretty much revolves around whether or not the same right that they have found people have in Washington, D.C., federal enclaves, to have an individual right to keep and bear arms. If that same person leaves Washington and goes to Illinois, to Chicago, do they take that right with them?
Right.
And I think they're going to say yes. Probably what's really got folks pondering is how are they going to get to that yes. There's a lot of discussion.
That's my point.
They may go through the due process clause of the 14th Amendment, in which case it would be setting the Second Amendment up for a kind of slippery, slidey.
It would be basically whatever the most relaxed jurisdiction is in the United States that's legal becomes the national standard.
Well, they would leave them a lot of room to regulate based on the kind of standard that has been developed around due process. If they rule that it's a privilege and immunity protected by that part of the 14th Amendment, then I think you're probably right that would make it a lot more difficult ultimately for a lot of these laws here and there to stand up.
Right.
So
here's what baffles me, Larry, and you're right. We're going to have to wait and see how this is done. I mean, Citizens United was originally brought as a case before the Supreme Court about one small subparagraph in the McCain-Feingold Act, and the Supreme Court decided to go all the way back to 1907 and blow up the Tillman Act. I mean, they decided to undo literally a century, more than a century, of Supreme Court decisions and legislative actions, blew the whole damn thing up. I mean, this is the most activist court that we have, I think, frankly, that we've ever seen in the United States. Arguably, John Marshall in 1803 accepted. But we'll see. But here's my question for you. Mayor Daley in Chicago, his response is that the federal government isn't responsible for determining what the standards of safety in his city should be. He is. It's his city, or he, and as the elected representative of the people. In other words, the people of Chicago are responsible for collectively deciding whether or not they want to have all the other citizens of Chicago, through majority rule, whether they want to have all the other citizens of Chicago be able to have pistols or not, or simply have long guns. And that's kind of a Tenther argument. That's a 10th Amendment argument, states' rights argument, as it were, or in this case, a community rights argument. And it seems to me like that's the most conservative argument there is what Mayor Daley's saying.
Well, I think the court may well answer him and say that even that 10th Amendment argument does not entitle a jurisdiction to violate a right that's protected in the Constitution. And it is kind of a logical twist, to say the least, to say that you can do something owning a handgun in the District of Columbia, but you don't have the right to do that elsewhere in the country, and yet the U.S. Constitution was used to reinforce that individual right. So the mayor's got himself into kind of a logical bind, it seems to me. The 10th Amendment is a great thing, and we're seeing states...
or the 9th Amendment even, which devolves powers to individual people.
Yes, in somewhat more specificity than even the 10th.
Right.
And we're seeing states assert themselves increasingly in the area of a pushback to nationalized medicine. In the Real ID Act, that was a dead letter.
Sure. When
so many states just said no. And there's a Firearms Freedom Act that's moving across the country that would essentially say that inoperative are all federal gun laws if a gun has been made in a state and stays in there.
Larry, we just have a minute to go. Here's a quick question for you. If the Second Amendment says in order to maintain a well-regulated militia, the right of individuals to have arms shall not be infringed, at what point is the right of public safety, which isn't specified as a right among the Bill of Rights, but I think we all agree is one of the purposes of government, maintain the general order, at what point does the need for public safety collide with the Second Amendment, and how do you parse that?
Well, you don't do it with prior restraint. We don't do it with prior restraint in speech. We say that you can't...
Well, we do with machine guns.
We say that you can't yell fire in a crowded theater, but we will punish if somebody actually does that.
But we do it with prior restraint with larger weapons.
Well, I think we've made a mistake in doing that with machine guns, but the founders were very clear that there was a limit to what they were talking about in the Second Amendment. What they had in mind from the Militia Act of 1792, which essentially codified all the colonial laws, said that you had to have a rifle, but if you were in an artillery company, you weren't responsible for bringing that.
Well, and they were mostly kept in armories, weren't they?
No, at home.
Oh, okay. All right. Larry, I didn't know. Larry, Larry Pratt, gunowners.org. You can read all about it over there. Larry, thanks for coming by today.
Appreciate you having me.
It's going to be real interesting to see what this decision is. Let's talk again afterwards.